The presentation or lecture, if you will, for chapter 2 is to be broken up into into smaller parts. You can look at the presentation and view the lecture by subject matter. And so this is the beginning of that series of lectures. Some objectives for this section. First of all, a little bit of a blowback from chapter 1 about the family law theory section that I feel like is important to enhance a little bit to clarify understanding of this for the students. First of all, the two objectives are listed here, excuse me, which I will not repeat aloud in the interest of time. Sources of family law is an important concept to begin understanding when you enter this course. Family law is a substantive area of law, and it is mostly a state law governed area. And state statutes are made by legislatures that govern family law. Courts have to interpret these statutes when they need to be applied to the factual situations of a case. So oftentimes the statutes are ambiguous, not clear whether they apply to a certain set of facts, and the courts will make these determinations. And so case law will help the family law practitioner to enhance their understanding of what the statutes say. Common law is often just very broad areas of the law. Property, contracts, and torts, they're traditionally part of the common law. Common law, I often explain, as if it's not a regulation or a statute or law made out of applying statutes and interpreting them, common law is everything else. But it is, and you're looking at this, I hope, and asking yourself, well, this is family law. We're not in a property class. We're not in a contracts class. We're not in a torts class. Why is Suzanne bringing up common law? Well, I bring it up because of the effects of property, contracts, torts, and other areas that just so happen to enter into family law or into family arrangements. So, you know, we can't exclude all these overlaps of areas of law that are, generally speaking, belonging to other areas. I mean, families still own property, families make contracts with each other, families injure each other negligently. So it is. And then it's important too to understand that, you know, we have the laws that govern, you know, families, and, you know, and the legal rights and obligations. However, when these legal rights and obligations have now, the other thing that can't be forgotten is that federal law does enter into the family as well. So while the Constitution provides that states will manage families and health and maintenance and health and welfare of its residents, and that is a very central concept to family law, the health, welfare, and maintenance of the state, of the people living within the state. However, we still have the supreme law of the land, the United States Constitution, and two particular areas of that come into play. The United States Constitution come into play. One is the 14th Amendment, and one is the Full Faith and Credit Clause. And here are some examples of things we see, you see in the media all the time, or that have historically been handled by the United States Supreme Court. And so we have opinions from the United States Supreme Court that are federal law because the United States Constitution um, is an overlap that handles areas like right to marry, right to procreate, etc., that are listed here. And then we have the full faith and credit clause, and as a result of child support issues, jurisdictional issues of which court has control of marriages from other states, and this is a big issue in terms of the DOMA law that is covered in part of the presentation here. So we don't want to exclude federal law. We can't exclude federal law, and so it is. In addition, we have federal statutes that also bring in some federal law questions. State child support collection agencies have been forced to follow federal laws made in that area of child support so that they can receive funding from the federal government to help them do this monumental task of helping to collect child support. Areas like tax interception, wage garnishment, and revocation of professional license is not necessarily just a piece of state law. Federal Congress provides for funding to state agencies to do those activities. And as a result, federal law seeps in with regard to areas such as child support. In addition, not listed here, but keep in mind, when people are married, they have different benefits that we're going to cover a little bit. Some of these benefits are federal benefits. For example, being able to file a joint tax return. That's a federal benefit. I can't file a joint tax return, at present anyway, until, never mind that point, but joint tax law is mainly a federal law area. Just keep in mind that we have some, while the federal government has historically wanted to stay out of the family relationships, no doubt the federal government has gotten involved, as the United States Supreme Court, in interpreting the Constitution as it relates to statutes, and the federal courts in applying federal laws in areas like the ones I mentioned. The next section of this particular section of the lecture is one to cover these two objectives of fundamental right to marry, understanding the difference between a civil marriage, religious marriage, common law marriage, covenant marriage, etc. Marriage is defined as began as a religious definition, a legal that constitutes a marriage, but legally it is a legal union of a couple, and it's a civil contract. Religious marriage, on the other hand, is governed by a faith. So civil marriage and religious marriage are different. And in some countries, the religious ceremony and civil marriage are very separate. In the United States, people tend to do that, to have a legal marriage solemnized by the clergy or congregation, and that it is one single instance of The next objective is to identify the types of legal rights and benefits that flow from marriage. This is this area of benefits from marriage is one of the biggest arguments today on the in terms of marriage, particularly same-sex marriage. When people are married legally and validly, well, let's say they have a legal marriage, there are many legal benefits that stem from that legal marriage. Probate protections in terms of the spouse of a deceased person may have some statutory, some legal right to a portion of the estate that that deceased spouse couldn't take away during his or her lifetime. For example, in the form of a will, writing a will disinheriting a spouse is typically um, not done, not permitted because of having state protections by statute. However, it can be done, and that's a contractual issue. Estate and gift tax exemptions, that has changed some with the Windsor case, which we're going to discuss later on. Family court jurisdiction for determining rights, so there's a place to go. People who are legally married have a forum of a courthouse to go to determine rights and have those rights upheld. Areas like federal government Family Leave Act, tax benefits. Again, these are rapidly changing areas that having a legal civil marriage typically invoke these legal benefits. But again, they are changing rapidly. All right, civil marriage also provides legal benefits like guardianship, hospital visitation, immigration, insurance. All of these benefits inure as a result of a valid marriage. Other benefits, I won't go into much detail on these, but these are just definitely benefits that are valuable to the married relationship as opposed to the unmarried relationship, of which we're going to talk about as we move through this presentation. Types of marriage, for example, in some states, as discussed in the book, there is a covenant marriage available, and these are where the couple gets involved in a marriage, but they sign a contract basically ahead of time that sets out some boundaries and groundwork for what they'll do if there are any problems in the marriage. Instead of getting a divorce, they will get counseling. But they have agreed to doing that ahead of the marriage, and so it's somewhat enforceable. The main idea of covenant marriage is to try to maintain the importance of marriage and continuing in marriage despite the problems that are sometimes very natural in marriage. And so that's the main idea of covenant marriage. This is simply an example of the Covenant Marriage Code of Louisiana, and you can look that up if you want to. But this is explaining, if you want to break this down, that they've thought about it carefully before getting married. They had premarital counseling. That they understand that covenant marriage is for life, and if there are marital difficulties, they want to take reasonable efforts to preserve the marriage, including marital counseling. And so they declare a marriage, and they have a civil marriage ceremony as well, but they look to the more historic principles of marriage to love, honor, and care for each other as husband and wife for the rest of their lives. So they're making a commitment beyond the standard civil marriage commitment, if that if that makes sense. I mean, in terms of how I just explained that.